Mr. Chris D'Souza.
Adili Chibuike EGK was charged with importing almost 2 kilograms of methamphetamine, commonly known as ice, into Singapore. A person will be guilty of importing under Section 7 of the Misuse of Drugs Act if he is in possession of the drugs, knew of the presence and their nature, and brought the drugs into Singapore without prior authorization. In practice, it can be difficult to prove a person's state of mind. To address this, the MDA builds in presumptions. When these presumptions apply, a person charged with importing prohibited drugs can be presumed to know of their presence as well as their nature. It is then for the accused to give sufficient evidence to rebut the presumptions. There is also the concept of willful blindness. Under the law, a person will be treated as having knowledge of a fact if it can be shown that he suspected something was amiss, yet did not verify his suspicion out of fear of legal consequences, and he had reasonable means of discovering the truth. Adili was arrested at Changi Airport in November 2011 after flying in from Nigeria. 2 packets containing close to 2 kilograms of ice were found concealed in the inner lining of his suitcase. Adili claimed that an acquaintance in Nigeria had told him to pass the suitcase to an unknown person in Singapore, and he was given about US $5,000 for his travel expenses. He claimed that he did not know what the suitcase contained, why he had to deliver it, and he did not ask those questions of his acquaintance. The one issue was whether Adili could rebut the presumption that he knew the nature of the drugs in his suitcase. The Court of Appeal noted that the prosecution, in their cross-examination of Adili and in their arguments in addressing this issue, had conceded that Adili did not actually know of the presence of the drugs. Members will appreciate, once the prosecution accepts that the accused did not know of the presence of the drugs, then the presumption cannot apply. The presumption allows the court to conclude that the accused did know. But if the prosecution accepts that the accused did not know of that fact, then obviously the presumption cannot be relied upon. This legal reasoning is neither novel nor new and is not in any way different from the government's understanding of the law. There are other observations made by the Court of Appeal on willful blindness. We are studying those observations carefully and will set out the government's views in due course and whether any legislative amendments are necessary.
Mr. Chris D'Souza.
Thank you, Mr. Speaker. My understanding is that the presumptions in the MDA continue to be a key legal tool to combat trafficking of drugs into Singapore, i.e. the supply of drugs. I'd ask the SPS to confirm whether my understanding is still valid and correct. And if it is valid and correct, that the presumptions continue to be a legal and muscular tool, then arising out of this decision, can the accused now claim a defense that he has no knowledge by virtue of the drugs being well concealed, rather? And I certainly hope that an accused should not be able to avail himself of such a defense. Thank you.
Our drug laws have been effective and remain so. We have presumptions under the Misuse of Drugs Act because it can be difficult to prove a person's state of mind, as it is something that is intangible and cannot be seen. The presumptions under the MDA imposes a legal burden on accused persons to rebut the presumed facts on a balance of probabilities. The presumptions were introduced precisely to address the difficulty of proving an accused person's subjective state of knowledge. This has been our policy intent right from the beginning. The fact alone that the drugs were well hidden would not cause the presumptions to be rebutted. Instead, the outcome of each case depends on a holistic assessment of all its unique facts and circumstances, as well as the evidence. Our courts in the past have carefully scrutinized such claims to assess if they are credible, such that the presumption is rebutted, and I'm confident that they will continue to do so. Moreover, when the presumptions apply, the accused persons bear the onus of persuading the court that such claims are credible and should be believed. The outcome of each case depends on its unique facts and circumstances as well as the evidence, and Adili's case turned on its facts. One point worth noting is the robustness of our criminal justice system. If the prosecution failed to discharge its burden of proof, an accused person will be acquitted.